Welcome everyone to our webinar this afternoon, Renting 101. My name is Judy Fang. I'm a staff lawyer at the Centre for Public Legal Education Alberta, or CPLEA for short. Our goal is to make the law understandable for Albertans. We're a nonprofit organization serving all of Alberta. We provide legal information and education through our 200 plus resources, 10 websites, and various projects covering a wide range of legal topics. With me here today, I have Natalie, who's our education and design specialist at CPLEA and the person behind the logo. And she will be monitoring the chat during the presentation and posting some things in there as we move through the content. And of course, I would also like to welcome our guest speakers today, Tim Patterson from the Edmonton Community Legal Centre and Joseph O'Curley from Service Alberta. So before we begin today, CPLEA respectfully acknowledges that we are located on Treaty 6, 7, 8, and 10 territories, the traditional lands of First Nations, Métis, and Inuit. So just a few housekeeping items. We're not circulating slides of today's presentation. Most of the information is covered in our extensive housing law resources, which we will mention later, and Natalie will be posting links in the chat. We're also recording the presentation and we'll make it available on YouTube at a later date. We will also save questions until the end. So we ask that if you have any questions, please input them with the Q&A function. You will also be prompted to complete a short survey when you exit the webinar. And of course, a disclaimer, the presentation today contains legal information and is not intended to be legal advice. And funding for this webinar is provided by the Alberta Real Estate Foundation. So what do we want to share with you today? Well, 3 parts to today's presentation. First, I'm going to provide a very brief overview of the law when it comes to renting in Alberta and establish at least some key principles to help inform our discussion today. Then I will chat a bit about trending topics and downloads at CPLEA, which will give us a current snapshot about the types of renting issues that people are seeking information about, and hopefully impart some key takeaways for our audience about those topics. And then, of course, the bulk of our webinar today will be a panel discussion with our experts, Tim and Joseph, and we'll discuss information and tips for dealing with common rental issues in more detail. Okay, so I guess we were supposed to pull up a poll question, Natalie, but I was going to ask how familiar are all of you with the Residential Tenancies Act, just to get a good sense of where our audience is at. So are you very familiar, somewhat familiar, not familiar at all? We would like to know. Okay, so there's a few of you, well, maybe not too many that are familiar. Some of you are somewhat familiar and not familiar at all. So I'd say most of you are somewhat familiar and not familiar at all. Okay, that's good. That's good for us in terms of a starting point. So what you need to know is that each province has their own renting laws. And in Alberta, the Residential Tenancies Act, also known as the RTA, covers the rights and responsibilities of most landlords and tenants in Alberta. That said, there are also certain settings or situations where the RTA does not apply. So for example, to nursing homes, lodge accommodations. And what you need to keep in mind is that the RTA contains minimum standards of conduct for both landlords and tenants. And there are also a number of associated regulations. So for example, there's a residential tenancies ministerial regulation, security deposit interest rates regulation, residential tenancies dispute resolution services, also known as RTDRS regulation. So we're not going to get into the details about these regulations with this webinar, but what you do need to know is that generally regulations set out how a statute, in this case the RTA, will function on a day-to-day basis. They can be changed more easily than statutes, so they often address topics where revisions are needed. And the Act may not always contain the most recent rules because the regulations may contain the most recent rules. Okay, and then moving on here, just a quick overview of some landlord responsibilities. Like this is by no means an exhaustive list, but these are some of the key landlord responsibilities under the Residential Tenancies Act and regulations. So for example, the landlord must make premises available for a tenant at start of the tenancy, not disturb the tenant's possession or peaceful enjoyment of the premises, ensure that the unit meets minimum standards under the Public Health Act and regulations, inspect premises within 7 days of the tenant moving in and out, provide a key to the tenant when changing locks, giving required notice to end periodic tenancy. So if the landlord does not follow the rules under the RTA and regulations, the landlord could be charged with an offense and also face a fine, and tenants can seek to end their tenancy or request financial damages if the landlord breaks these rules. Likewise, tenant also has responsibilities under the RTA, and these are what are called covenants under the RTA. So for example, tenant must pay rent in full and on time, not interfere with the rights of the landlord or other tenants, no illegal activities in the rental property, not endangering other people or the property, do not cause significant damage, keep property reasonably clean, and move out when the tenancy is over. And if the tenant does not follow these rules, the landlord has a right to end the tenancy, evict a tenant, and seek damages in court. So moving on here, when we are talking about the legal landscape when it comes to renting, we can't forget about residential tenancy agreements. So these are also known as a lease or a rental agreement. And what it essentially is, it's a contract between the landlord and tenant or tenants that set out the rules that both parties need to follow. Usually agreements are in writing. They are not required to be in writing, but it is a good idea for them to be in writing to avoid future disputes about what was agreed to by both parties. Okay, another point to keep in mind with tenancy agreements, really like to think of them as there's two types. There's periodic tenancies, typically month to month, can be weekly, and really it keeps going until the landlord and tenant ends it. And then there's also agreements for fixed term tenancies, which begin and end on a specific date. Okay, so why is this all important, what I'm telling you? Well, first of all, tenancy agreements usually include terms from the RTA. So for example, agreements will often include information about when and why notice can be given to end them, which is an issue covered under the RTA. And also different rules apply to different types of tenancies under the RTA. So for example, when a landlord can end a tenancy, when a tenant can end a tenancy, and also rent increase notice. Another important thing to keep in mind is that the RTA will always be enforced over any agreement that the landlord and tenant makes on their own. So in fact, every written residential tenancy agreement has to include a statement in larger print than the rest of the agreement that says the tenancy created by this agreement is governed by the Residential Tenancies Act. And if there is a conflict between the agreement and the act prevails. Okay, so moving on here. Oh, there are also other laws that deal with specific issues in rental properties. So for example, we have the Mobile Home Sites Tenancies Act, which deals with landlord and tenant issues relating to mobile home sites. Condominium Property Act, which contains rules that tenants living in condominiums have to follow. Alberta Human Rights Act protects tenants from discrimination in rental housing. Alberta Building Code sets standards for the design and construction of buildings and changes to buildings. Safety Codes Act sets standards in areas such as building, fire, electrical, gas, elevators, plumbing, and private sewage. Of course, we also have the minimum housing and health standards under the Public Health Act, where the Public Health Act requires landlords to keep their properties safe, sanitary, and habitable. And landlords must meet the requirements in the minimum housing and health standards. And there's a number of them. We also have the Personal Information Protection Act, which protects individual privacy by requiring landlords to obtain the tenant's consent when collecting, using, sharing personal information. And of course, there's municipal bylaws, which deal with more local issues such as noise complaints and sidewalk snow removal, that type of stuff. So now we've established the overall legal landscape. Let's talk a little bit about trending topics right now at CPLEA. So these trending topics are based on our website analytics. These are the types of pages and topics that people are searching for and accessing the most so far in 2022. So the first being eviction notices, second one being roommates, and third being rent increases. So if Natalie could just pull up the poll right now, we're going to have a little bit of a pop quiz. Okay, so evictions. What do you think? Do you think a tenant can be evicted for not paying rent? Okay, so most of you did answer yes. We did have a response that's no. Okay, so what is the answer? Well, the landlord can evict the tenant if the tenant commits a substantial breach, which means a breach of one of the 7 rules for tenants from the RTA, as I discussed a little bit earlier, or a series of breaches of the lease. And this includes not paying rent and even repeated instances of not paying rent on time. Okay, and when it comes to evictions, we have developed an eviction chart for Alberta. You can see what must be included by law in a 14-day eviction notice. And if the landlord doesn't follow the law as they should have, the chart explains some options that the tenant has for next steps. Okay, and then as another tip though, if you're facing an eviction and you do not know what to do, then you should be getting some legal advice. Okay, second trending topic here has to do with roommates. Okay, so what you need to know about roommates is that the RTA covers obligations between landlords and tenants and not between roommates. The RTA does not apply to landlords sharing living space with their tenants. And in these types of situations, written agreements apply. And if you want some more information about this, these are all, we do have quite a bit of resources on roommates and related topics on our website. Okay, moving on with the third trending topic here. Okay, so there's often a question about whether there is a limit on how much a landlord can increase rent. Okay, and really it boils down to this: there's no limit on the amount of increase. The legislation doesn't specify a limit on the amount of rent increase or cap, or even a cap on rent, unlike other provinces. And another thing to keep in mind is with rent increases is that you can only increase rent after 365 days, or really 1 year has passed from the start of the tenancy or the date of the last rent increase. So for more information, we do have a tip sheet on rent increases as well. Okay, so moving on, let's talk a little bit about top downloads right now. Maybe perhaps as a sign of some issues to come. Well, our analytics show that the top 3 publication downloads right now are what they have to do with what happens when a property is sold. So the place you're renting is sold is number 1. 2 is our renting basics guide, which is a easy read guide to renting in Alberta, and also renting with a pet. Okay, so moving on now, here for our panel discussion with Tim and Joseph. Recognizing also that, at least with our organization, there are limits in terms of what we know about people's problems when it comes to renting. And of course, with our own data that we have at our organization, we only have a snapshot of what people may be thinking about or dealing with. But then what happens when they actually reach out to, say, Service Alberta? What type of problems are they talking about there? And they might want some help with? And also what actually ends up at perhaps like a dispute resolution stage, say for files that end up at your desk, Tim. So I think that's kind of what we want to explore a little bit more further with our discussion as well. So I do want to introduce Tim first. So after graduating from the University of Alberta Law School, Tim worked in private practice in the litigation department of a large law firm for several years before changing course and joining the Edmonton Community Legal Centre, where he has practiced for more than 13 years. In his position of civil staff lawyer, he helps clients who would not otherwise be able to get legal assistance with landlord-tenant, employment, debt, human rights, and a host of other issues. And other roles that Tim has include, he's a dad to 3 boys, he's a hiker and a somewhat reluctant mountain scrambler. Okay. And of course, we also have Joseph. So Joseph is a statute administrator with Service Alberta and the delegated director of residential tenancies. He is responsible for administering and providing subject matter expertise on both the Residential Tenancies Act and the Mobile Home Sites Tenancies Act, and is also responsible for administrative enforcement under the Consumer Protection Act. He has a legal background and has also worked in government in various fields at both the municipal and federal levels. All right, we're going to start off with our first question here. So what are the top 3 landlord-tenant issues that people need help with when they contact your organization? So maybe, we'll start with Joseph first. Let's hear from you.
Sure. So COVID has kind of distorted things a little bit, but our top 3 non-COVID related subjects are what tenants' options are when they receive a termination notice. I should point out that most of the contact that we get is from tenants. We do get some landlords, but it's mostly tenants. So the number 1 is issues surrounding termination. And we often get contacted toward the end of the notice period. And so timelines are tight, but tenants are mainly just looking to see what their options are, what they can do. So that includes things like objecting to the notice if it's for something other than non-payment of rent, paying outstanding rent, or applying for a dispute resolution. The second most common inquiry or type of inquiry that we get is how to get landlords to repair or maintain the premises. And while there is a provision under the RTA that requires landlords to comply with the Public Health Act, there isn't any actual enforcement mechanism in the RTA to force them to comply. So their option there basically is to contact AHS, Alberta Health Services, who Alberta Health Services actually has the jurisdiction to inspect and enforce the requirements under the Public Health Act. The third most common is concerns surrounding security deposits. So primarily it's concerns around deductions, what the landlord can and can't deduct for, but also the method and the timeline for refunds when it comes time, when tenancy is finished. So a couple of things that pop up there. We do get questions coming from both landlords and tenants where it pertains to security deposits. A lot of landlords don't realize that they can't impose deductions for normal wear and tear of the premises, and they can't deduct for things that the tenant didn't agree to, that wouldn't constitute, damage to the premises or something like that. A lot of tenants also don't realize that a security deposit is not a substitute for the last month's rent. Some other provinces have that, like Ontario, for example. It's common in some places in the States. So if somebody sees it on TV where they say, I paid my first and last month's rent, that doesn't apply in Alberta. So tenants can't just say, I'm not paying my last month's rent, because the landlord can just keep the security deposit. So those are the 3 most common issues that we get. We also do get questions about rent increases, what the landlord can and can't do. And then, as I mentioned, COVID kind of skewed things. So we did get quite a few inquiries related to landlord entry and whether a tenant has to vacate at the end of their tenancy or if their tenancy is terminated, if they're in isolation and quarantine. But those are kind of petering off now. We're not getting quite so many of those. And yeah, so that's the main ones that we've got.
Okay, that's good to know. I did actually have one question because it often comes up with what we hear from with resource users, like, you know, what is it exactly normal wear and tear?
I mean, it's hard to answer that outright, but it basically is something that would not be expected to occur through normal use.
Okay.
So if there's like holes in the walls or physical damage to appliances or plumbing or something like that, I mean, again, it's circumstantial. I can give examples of something that's obviously an example of something that's not normal wear and tear, but things like, you know, the carpet has wear on it, like that a landlord couldn't deduct for, or regular scheduled painting, or shingle replacement where there's no specific damage that's the tenant's fault, like that kind of stuff would constitute normal wear and tear.
Okay, thank you. All right, Tim, top 3 landlord tenant issues at the ECLC.
So in no particular order, and I didn't do a bunch of drilling down into our data, so it's kind of off the top of my head, but I think I have a pretty good general sense of what we see. I'll start with what we were just talking about, which is return of the security deposit, and that often implicates the notion of ordinary wear and tear and what that is, and there's often a dispute over that. And I agree with how Joseph has defined it. I mean, it is sometimes difficult to define, and there's not a lot of sort of guidance from the courts, just because there's not a lot of cases that are published that deal with landlord-tenants issues. There's a lot of landlord-tenant cases, but they don't publish a lot of the results, and so it can be sometimes challenging to define that. And I noticed in the chat there's a question about floorware, and yeah, that's the classic one is the carpet. And there actually is a case in Alberta that says that a landlord really can't charge or require a tenant to have the carpet steam cleaned. That actually is sort of ordinary wear and tear. Now, it would be different if there was a bad stain or something that was left on the carpet, or if it was extraordinarily dirty or something like that. But for ordinary wear and tear, it's a case that has been around since I think the 80s, but sort of routinely ignored or just not known about. So that's kind of interesting. I would say another top issue that we see are eviction applications. We primarily or almost exclusively deal with tenants in our practice. And so we're usually giving advice to the tenants when either faced with an eviction application by the landlord, or sometimes they come to us before there's an actual application at the RTDRS, or Residential Tenancy Dispute Resolution Service, or the courts, and they'll come to us for advice where an eviction is threatened. And that can be lead to a whole lot of other legal issues, because of course eviction can be for a number of different grounds. It can be for non-payment of rent. It could be for frequent non-payment or late payment of rent. It can be for things like if the tenant is threatening or harming other tenants or the landlord, or other substantial breaches. And so, we see a lot of that, and we give a lot of advice to tenants about eviction applications and about what they can do if they believe that their landlord doesn't have good grounds to evict them. And then I would say the last or the third sort of big chunk of files that we see on landlord-tenant issues is about rent abatement applications by tenants. So rent abatement is basically a return of rent that's already been paid Sometimes it can be in order for paying less rent going forward, but usually it's a return of rent already paid because the tenant wasn't getting what they bargained for. So if the landlord has committed a breach of either the RTA or the lease agreement, and that then the tenant might be entitled to return of some rent because of that. And again, those also are tricky to deal with and to give advice about because the amount of rent abatement is not really defined anywhere, and there's not a lot of guidance in the courts. And so a lot of times it's a bit of a judgment call as to what is the appropriate amount of rent abatement in a particular case. So those are the sort of three big areas I think that we see.
Okay, good to know. So we're just moving on to like question number 2 here. So let's say a landlord or tenant is having problems with your utility provider. Where can they go for more help potentially? Joseph, do you want to take this one first?
Sure. So it really depends what the specific problems are with the utility provider. If there are concerns about electricity or natural gas contracts or submetering, which is, say, in a multi-residential building, if a landlord doesn't just charge rent with utilities included, but has individual meters on the units, and the tenants pay their utilities directly. If there are issues with those, both landlords and tenants can contact the Service Alberta Consumer Contact Center if the matter falls under the Consumer Protection Act. The specific circumstances, again, it would depend on what those issues were. But other than that, individuals can contact the Utilities Consumer Advocate of Alberta or the Alberta Utilities Commission, depending, again, what the issues of concern are.
Okay. And is there like a dispute resolution mechanism that's offered by like the Utilities Consumer Advocate as well, or maybe a little bit of information about what they could potentially do?
I'm not entirely familiar with exactly what their process is. I know that they can mediate,
Okay.
and the Utilities Commission can receive complaints. So in terms of dispute resolution, I mean, mediation, that is an option there. But again, I just know that they can. I don't know exactly how they go about doing that.
Okay. Tim, how about your thoughts on this question?
Yeah, I don't have a ton to add to this. I actually don't deal with a lot of those type of issues. And I think partly it's because we have a good intake department here at the ECLC. And I think those type of questions then get referred out before they even come to my attention. But it was a good question because it forced me to do some research, and I can confirm everything that Joseph's been saying, and learned a little bit about the Utilities Consumer Advocate, who does have mediators that can assist. And then there is a complaint mechanism at the Alberta Utilities Commission. But I would also echo too that if utilities are included in the lease, then the issue really is for the tenant with the landlord, and the tenant will need to take it up with their landlord first. Because that's really a dispute that would fall within the tenancy agreement, and could potentially be the subject of an RTDRS application or a court application if the dispute rose to that level.
Mm-hmm. All right. So question 3 here. What can a tenant do if they have a complaint about their landlord? I know this is quite broad, of course. And I was thinking, it seems to be that there's more issue-specific complaints. And Joseph, you did mention a little earlier, like if it's something that has to do with the Public Health Act and minimum housing and health standards, you should be getting in touch with like the Environmental Public Health Office, 811, that type of place. And then there's also like a question about offenses, right? So I just want to know, like, when would be a circumstance, say, when a tenant would contact Service Alberta Consumer Investigation Unit about something?
Sure. So for offenses under the RTA, and not every violation of the RTA is an offense. So offenses include things like if the landlord didn't provide the required notice with their contact information, keeping copies of inspection reports, if they don't follow the rules around entry of the premises, if they change the locks, if they retaliate against a tenant for making a complaint against them, those sorts of things very specifically are offenses under the RTA. And if a tenant is of the opinion that their landlord has committed an offense, our intake process is to go through the Service Alberta Contact Center. So the Service Alberta Contact Center receives the complaint and then passes that on or refers the complainant to the Consumer Investigations Unit. So I should say that investigations under the RTA are rare, not because of any policy or any or resourcing issue or anything like that. It's just that we don't receive that many formal complaints under the Residential Tenancies Act. Most of the complaints that we get are Consumer Protection Act related. And I should mention that as well. It hasn't actually been determined whether in court or through statutory provision, whether the Consumer Protection Act applies to landlord and tenant relationships. We have legal opinions going both ways and interpretations going both ways. But it's basically an open question at this point. However, if a tenant feels that the landlord has violated specifically issues under Section 6 concerning unfair practices, so if they have misled or deceived or tried to impose harsh or one-sided contract terms, then the tenant could conceivably submit a complaint under the Consumer Protection Act. But the process would be the same. The process would be contacting the Service Alberta Consumer Contact Center, basically describing their situation, and then the Consumer Investigations Unit would take it from there.
All right, thanks, Joseph. Tim, would you have anything to add to this?
Only that, yeah, I mean, it really depends on the type of complaint. Again, if it's a matter of whether the landlord's, not meeting the minimum housing requirements, like in terms of, the health and safety of how the building or unit itself is set up, then that really is something that should be brought to Alberta Health Services, the Environmental Public Health, to their attention to do an inspection. And I would say, I mentioned rent abatement early on in the answer to a previous question. And we tell people all the time when they come to us and they're looking maybe potentially for rent abatement because of things like that, they should get that inspection, because that's really important evidence that they're going to need if they want to make such an application. So that is an important avenue. And then, I mean, ultimately, if the tenant or the landlord is looking for a remedy, like a monetary remedy for damages that they're experiencing, then they would need to bring an application either to the RTDRS or make an application to the court in order to get a judgment. Because my understanding, and Joseph can correct me if I'm wrong, is that the Consumer Investigation Unit has the remedy of maybe fining the landlord who's violated the act, but they don't provide compensation to the tenant. But you feel free to correct me if I'm incorrect.
No, that's absolutely correct. And I was going to make a point to say that in terms of just on the topic of applying to RTDRS or provincial court, I did want to note that neither of those two have the ability to order specific performance. So if a tenant say a tenant has a health and safety concern and they're submitting their application to Environmental Public Health and going that route, Environmental Public Health has the authority to order specific performance. But if the tenant is going to RTDRS or provincial court to apply for a remedy, there is no remedy under the RTA that would force the landlord to comply. The RTDRS or a provincial court can't order a landlord to say fix the plumbing under the RTA. The tenant conceivably could apply to Queen's Bench for that, but that's an escalation that for most tenants isn't really something that they want to pursue. But I think that is an important point. The RTDRS and provincial court can't basically make any sort of order to tell the landlord to do something. They're limited in terms of what remedies they can provide.
Okay, that's good. I feel like, we also covered a little bit of the next question, what we just discussed here, but, options available in resolving landlord-tenant dispute. And of course, like from my understanding, most landlord and tenant disputes under the RTA do end up before RTDRS, correct? And then, there might be more specific circumstances where they may end up in provincial court. So maybe Tim, maybe chip in a little bit about all of this.
Sure. I mean, in terms of, options to resolve disputes, I always start with negotiation and dialogue. That's always the best way and best place to start. Tenants and landlords should be talking to each other and trying to resolve disputes, because litigation, whether that's at the RTDRS or in court, is time consuming and expensive and annoying and can take time. And it's best if any disputes can be resolved through negotiation and dialogue. So always start there and keep at it, and sort of view the other options as when that fails, then you can look at moving on to other things. And before the RTDRS, I will mention too, there are some mediation services available. There used to be a city endorsed organization called the Landlord Tenant Advisory Board. My understanding is that they are no longer operating, but they did provide some mediation services. The reason I'm mentioning it is that I was just looking on their website, on the City of Edmonton's website. It looks like there's still some mediation services available through them, so that is an option. But for most people, it's probably makes sense to, if negotiation and dialogue has failed, to move to the next step, which is making an application to the RTDRS. So the RTDRS, a Residential Tenancy Dispute Resolution Service, it's a big mouthful, that's why we keep saying RTDRS, is an administrative board that hears disputes between landlords and tenants, and they have the ability to make an order that is enforceable. So they can order the tenant to pay rent to the landlord. They can order the landlord to provide rent abatement to the tenant. They can evict tenants, and they can order that security deposits being returned. Basically, almost anything under the RTA, the RTDRS can give an order for, and then that order is filed at the Court of Queen's Bench, and it's enforced as if it were a Court of Queen's Bench order. So that is a pretty powerful remedy, and it's also a system that's set up and designed so that people can participate in it without having legal representation. So you don't need a lawyer to go to the RTDRS, and in fact, most people, landlords and tenants who go to the RTDRS, do not have lawyers. And so that is the most popular and in most cases the dispute resolution mechanism that makes the most sense. Now, you can still bring an application to the provincial court and actually to the Court of Queen's Bench. And there are certain limited cases where that may make some sense. But those are the type of cases that you'd probably want to get some legal advice beforehand, just to make sure it's appropriate. And the other thing is that the RTDRS can transfer matters that they feel like they don't have jurisdiction to hear. They can transfer them directly to court, whether it's to the provincial court or to the Court of Queen's Bench. So those are the main dispute resolution mechanisms that I deal with in my everyday practice.
All right, thank you, Tim. Joseph, do you have anything to add?
No, I think Tim covered pretty much everything.
Okay, that's great. So this kind of leads to my next question as well. So let's say a landlord and tenant have a problem and they try negotiating and it didn't work out. So when it comes to actual problems that end up, say, at RTDRS or provincial court, Tim, what are your thoughts, or what are your tips for people when it comes to attending these types of hearings?
Well, I'll start with well before attending, because I think this is really important. When you're having a dispute, and in fact, anytime you're interacting with a landlord or a tenant, you really need to document what you're doing. Because that is, in many cases, that's the difference between being successful or unsuccessful in an application. And it doesn't need to be really formal. You just need to make sure that the conversations that you're having are somehow documented in writing, even if it's just a text message to follow up saying, hey, we had a conversation, just confirming this is what you agreed to. Because if you're at the RTDRS and you're a tenant and you're saying, yeah, my landlord agreed to reduce my rent for this month, and the landlord shows up and says, no, I didn't. I mean, it's really difficult to prove that, right? But if you have a text message that said, hey, I sent that you sent saying, this is what you told me, and the landlord replies, yeah, or doesn't reply at all, but you know, you can show that they got it. That's important. I also say that for when you're moving out, take pictures. If you're a tenant, take pictures of the place and the condition that you left it in. If you think that there's going to be a dispute about the return of your security deposit, or even if you don't think there's going to be a dispute, it's just good practice to do that. So that's before you even get there. What I would say, once you're at the point of making an application, make sure that you're submitting all the documents that you need, because if you don't submit your documents, you're not going to be allowed to refer to them in the hearing. So make sure you get all of your ducks in a row for submitting documents. In preparing for the hearing, be organized. You need to tell your story in some sort of order, and usually the best order is to tell it in chronological, or in, you know, this happened and then this happened and then this happened. But sometimes it makes sense to organize it by subject. So if you've got a bunch of different complaints, you can kind of group it together, but have some sort of organization. Remember, this hearing officer is pretty much coming in cold, and this is the first time they're hearing the story. They might have, you know, read your written materials, but you need to put it into context for them and help them understand what it is. And then as you're telling your story, if you have documents that support that, you need to point the hearing officer's attention to those documents. And then the other thing I would say is be very clear about what you're asking for. Are you there to ask for that you're going to end the tenancy? If you're a landlord, do you want this person evicted, or do you want a conditional order that's just going to require them to pay rent over the next few months? If you're asking for damages, whether you're a landlord or a tenant, make sure you have some idea about how you're calculating those damages. And you need to be realistic about that. So for example, if you're a landlord and you want to charge, you want to get compensation for the damage that a tenant's caused, you're not going to get full replacement value. Like, so if there's damage to the carpet, you're not going to get the cost of a brand new carpet. You're going to get something less than that. So you need to be realistic. And then on the other side, if you're a tenant, it's pretty rare that you're going to get full 100% rent abatement. So all of your rent back for months, because you likely derive some benefit of living there. So you just need to be realistic, and you need to be able to be in a position to tell the person hearing your matter, whether it's an RTDRS officer or a judge, what it is you're asking for and why you're asking for it. So those are my sort of general tips for the RTDRS or a court application.
Okay, thank you so much, Tim, for the practical tips. Joseph, would you have anything else to add about this?
I think Tim covered most of it very well. Definitely if seeking damages, to try to quantify them, that's a very important recommendation. The other things are very simple, basically, like be on time, give yourself enough time for the hearing. If you have a witness, make sure they're available and on time, that sort of thing. I believe all RTDRS hearings are now telephone hearings. So that was done with the intent of making it a lot easier to actually attend them. So they're hopefully are resulting in fewer no-shows. The other thing that I would probably recommend is try to keep it focused on the issues. This is hard for a lot of people to do, but when there is a breakdown in relationship between a landlord and tenant, things can get very personal. And a lot of the time, the personal issues, it's at the forefront of the individual's mind, but they're not necessarily relevant to the issues that are being addressed, or the issues that can be addressed by say, RTDRS or provincial court. So try to keep it not so personal as much as possible. I mean, it's difficult, as I mentioned. The other thing is to be respectful. because things can get personal, they can get heated. And grievances can bubble up, and tempers can flare and that sort of thing. So the main thing there is to just try to focus on what needs to be done and keep things cool. But other than that, I think Tim covered everything very well.
Okay, great. Thank you, Joseph, for the additional insight. So I mean, really, this is like the last question, at least amongst us, when it comes to discussion. But what other resources are available for people when they want more information about or help with landlord-tenant issues that maybe we haven't already discussed? So maybe Joseph?
Sure. And I know that there's been a bunch of links posted in the chat. Service Alberta publishes a lot of resources online, especially with the RTA. For mobile home site tenancies, which we're not really getting into today, we're working on getting resources published there, but we do publish a website that it should be very easy to find. If you Google Alberta landlord tenant, it should be the first result that comes up on alberta.ca. So it should be very easy for people to find. And then there's various topics, whether it's security deposits or terminations or whatever. There's information there that covers generally what those situations may require. We also have more comprehensive documents that we refer to as tip sheets. We also have a guide that are published, and there are links to those documents on the alberta.ca website. In addition to that, we have the Service Alberta Contact Center. So in addition to being able to receive complaints, they can also provide information. So individuals can call them if they have any questions about landlord and tenant issues. As mentioned earlier, well, not in this particular circumstance, but a lot of people are seeking legal advice or advice in general. The contact center can't provide that. They can just provide information and clarification on what the rules actually are. So those are the main resources that we have available from Service Alberta.
Okay, all right. Thanks, Joseph. Tim?
So then I'll pick up on that last point. If you are looking for legal advice, then organizations like my own, the Edmonton Community Legal Centre, is a good place to start. We do have an income test, so we're there to serve low-income clients. So we can't necessarily help everybody, but if you're not in Edmonton, there are services in other communities. There's Calgary Legal Guidance, Grand Prairie Legal Guidance, Central Alberta Legal Clinic, which is in Red Deer, and serve a few other communities around there. There's a Lethbridge Legal Clinic as well. So there's a bunch of resources around the province. For the most part, those would be for tenants. There's also student legal services here in Edmonton and student legal assistance in Calgary. If you're a student or just low income as well. If you're a landlord, there's the Alberta Residential Landlord Association. So that's like, I think, I don't know a whole lot about them, but they're at albertalandlord.org. And they, I think, provide advocacy and support to landlords. And you can get forms from them and probably get information about landlord-specific topics there. So there are a number of good resources out there to help people who need some help. Okay,
thank you so much, Tim and Joseph. So I think we're going to leave some time for some questions from the audience here. But before we get there, I do want to mention that for those who are not familiar with our organization, CPLEA.ca, you can go to our website for more information, publications and resources, and also to order print publications. And we do have a specialized website that covers landlord and tenant issues, landlordandtenant.org. Couple of upcoming webinars in the spring, family law update, meet CPLEA, and also working on a webinar on covering the ban on conversion therapy. So we're just going to dive right in here, see what type of questions that we have from our audience. And let's see here. Okay, so the first question here. So in a periodic tenancy, is there any reason that the landlord is required to give to end the tenancy if they give the proper full month notice, or do they have to have similar reasons as for evictions. So question around ending periodic tenancies and the law around that.
It's a good question. I can answer it, Joseph. You might want to weigh in as well. But the answer is, well, I actually don't know if it's yes or no, because there's a few questions in there. Yeah. But a landlord needs a reason that's recognized in the Act and its regulations in order to end a periodic tenancy. And this is an important difference between a fixed term tenancy and a periodic tenancy. So in a fixed term, remember, there's an end date. And so the tenancy ends on that date, and there doesn't need to be any notice. In a periodic tenancy, which is usually month to month, the landlord needs a reason, and there's a bunch of reasons set out in the Act. They don't need to be the reasons that are similar to an eviction for, say, a substantial breach. You don't have to wait for default on rent payment or something like that. But it has to be for some very specific reasons that include you're converting the unit into a condo, you're having a relative move in, or family member or relative, that can be a reason. You're selling the place, although you can't just evict a tenant or give notice to end a tenancy because you put it up for sale. There has to be a conditional sale or a sale in place with the conditions removed before notice can be given to the tenant. But that can be another reason. If the place is being demolished is another one. There's maybe one or two other ones and I'm forgetting, but those are the main ones that I see. And if it's not for one of those reasons, then, and if there is no breach, then a landlord can't end that tenancy.
Okay. Joseph, anything to add to Tim's answer?
No, I think that covered most of it. I should note that I believe, yeah, the most of the available reasons are covered in the regulation, but they are limited. For a periodic tenancy, a landlord can't just say, you know what, I'm going to see what other tenants I can get, or I just don't like you, or something like that. Like they need to have a specific designated reason in either the Act or the regulations.
And I will also mention in this context, there's a really big trap that exists in the way that the legislation is currently worded. I think there's one reason where in the Act it says 180 days notice is required. And then if you look at the regulation, it actually modifies it to 365 days. So there's a big increase. And I think that's for, I shouldn't say because I can't remember if it's for major repairs or condo conversion or something like that. I think it might be for condo conversion, but just be aware of that. Make sure if you're looking at it, look at the Act and the regulation, because you need to know that in order to get the right notice period.
Yeah, there are different rules based on the specific circumstances.
I hope that answers that question. Moving on. So I guess what to do if a roommate refuses to move out and refuses to pay rent?
I mean, I can provide an answer that's probably not that satisfactory to most people. Basically, when you have two tenants sign on a contract, they're both bound by the terms of it. So if a tenant refuses to move out and refuses to pay rent, if there is a co-tenant, the landlord can try to collect rent from that other co-tenant, and they're still bound by the terms of the contract. If a tenancy is terminating and the person is refusing to pay rent and refusing to move out, depending on the circumstances, if both tenants refuse to pay rent, the landlord can move to terminate the tenancy based on non-payment of rent. But the Act doesn't really provide a lot of guidance in terms of what to do when there are more than one tenant on an agreement. Basically, the relationship between landlord and tenant are the tenant can go after either, or the landlord can go after either tenant for whatever the tenant or both tenants are bound to comply with.
Tim?
Yeah, I agree. I mean, the answer really is choose your roommates very carefully. And if you don't know them very well, or even if you do know them very well, it's a good idea to have a roommate agreement that really sets out all of those things, because Joseph is right. In respect of the landlord, both tenants are fully responsible for all of the rent to that landlord, and can be evicted for the non-payment of one, and can be held to judgment for the full rent if the rent isn't being paid. And then the only remedy the other tenant has, the one who has been responsible for paying rent, is to make usually file a lawsuit in provincial court against the other tenant to try to collect that money back. So yeah, it's as Judy mentioned at the beginning, it's not covered. The Residential Tenancy Act doesn't apply as between roommates. It only applies between tenants and the landlord.
Okay, that question I hope is answered. Next one here. So I think this is probably more geared for Joseph. So what's the difference between the Consumer Contact Center with Service Alberta and the one over at RTDRS?
Okay, so the Consumer Contact Center, as I mentioned, their primary role with regard to landlord and tenant is to provide information. So they can clarify roles and responsibilities under the RTA. As I mentioned, they can also receive complaints if especially with regard to offenses under the RTA or potentially under the Consumer Protection Act. That process, as Tim, I believe, mentioned, doesn't really get the tenant anything other than some moral satisfaction. If the landlord gets a fine, they can't. The Consumer Contact Center and subsequently the Consumer Investigations Unit can't really order a landlord to do anything. They can issue a ticket basically, or a fine. So it's not going to get the tenant anything tangible in that regard. The RTDRS is it's effectively a substitute for provincial court. It's a dispute resolution service, and within their the jurisdiction that they have under the Residential Tenancies Act, they can actually order specific remedies with regard to financial compensation or damages, rent abatement, termination of tenancy, those sorts of things. So they actually have authority to order things. Their role is not so much to provide information or guidance to tenants or landlords. Their goal or their role is to resolve the dispute.
Okay.
Hopefully that answers that.
Yep. Okay, and the next question here, I believe probably Tim would be more familiar with this, but are there any additional resources for low income or subsidized renters? You did mention a little bit earlier, just potentially places to get legal advice, but I'm not sure if the resources extend maybe beyond that. In terms of
I think we've covered. I think I covered most of the sort of legal advice resources and help, like legal help resources. If the questioner is referring to like financial resources, there are subsidized housing providers in the city. Unfortunately, there are long waiting lists for that, but it is something that tenants, if they find that they're in a position where they can't financially afford sort of to rent at sort of what the market rates are, and it seems like the market, I don't actually know if it's going up or down, but it can at times be expensive. So there are subsidized housing providers out there that you can look into. But I think we've covered most of the sort of legal advice and legal assistance resources.
Yeah, for sure. And then it seems like we do have one final question here. And this is directed to Tim. So can you share criteria for financial eligibility for ECLC?
I can't, but not because it's a big secret. It's just that I because I don't do the intake, I'm not familiar with them off the top of my head. What I can say is it's a sliding scale, so it depends on family size. And the question was for the Edmonton Community Legal Centre, yes, right?
Yeah, for
ECLC. So it depends on your family size. I can say that the guidelines are a little bit higher than what they are at legal aid. So if you qualify for legal aid, you probably qualify for our services. Yeah, beyond that, I can't really get into a whole lot of specifics, mainly because I just don't remember what they are.
Okay, great. It looks like we have no more questions here. So this concludes our webinar, and thank you so much, Tim and Joseph, for joining us this afternoon. Your insight is greatly appreciated.
Can I make one?
Yeah.
Sorry, Judy. Can I make one more point before we go? Because it was mentioned in the chat, and I just wanted to put it on the video and audio that that notice requirement that I was talking about was for major renovations. The 365-day notice requirement was to do major renovations. So I just want to make sure that that gets put on the video and audio portion of this.
Oh, okay, sure. Sounds good. I'm just making sure, like, I know we were going to conclude this, but I do realize that we might have some questions that were input into the Q&A. So I'm not sure if you have other engagements for this afternoon. Maybe I'll just do a quick browse and see if there's any questions or in the chat. Is that okay? Okay, so maybe we'll just, do a quick perusal here. Okay, I do see a comment here about floorware. Any comments about that?
I mean, in terms of whether or not it can be used to deduct from the security deposit, it's hard to say specifically what the threshold is, and I'm not really in a position to say, this amount of floorware constitutes normal wear and tear, and this constitutes, undue damage. It's really hard to say.
Yeah, I agree. I mean, the way I kind of view it is, if you're living your life normally and taking your shoes off when you walk into the place, and that's normal wear and tear. If you're walking around in your muddy gum boots in and out of the place and grinding dirt into the carpet, well, that might be beyond normal wear and tear, and you might be responsible for those damages. So those are the extremes, and there's lots of edge cases in between.
That's great. Okay, one last question here then. Let's say a tenant didn't pay utilities. Is the homeowner responsible for it?
Kind of comes down to the terms of the tenancy agreement and who the utility accounts are assigned to. There isn't really like a bright line one way or another. Yeah, sorry.
Okay, Tim?
Yeah, I don't actually have a lot of knowledge of that. Again, the utilities can be in either the tenant's or the owner's name. I think there is some provision now that if like a tenant stops paying, then the owner, I think, might get notified just because they have an interest in maintaining the property and making sure that utilities are to it. But I'm not actually sure if the owner is ultimately on the hook for unpaid utility bills. Don't know the answer to that.
Okay. Any more final thoughts?
I do have one point on the issue of financial supports for low-income renters. It's not landlord tenant specific or specifically targeted towards renters, but Alberta Supports does have income support and other potential resources for low-income people. So if people are in a tight spot, they can reach out to Alberta Supports and see if they're eligible for any support programs that they have.
Okay, perfect. Thank you so much, Joseph and Tim. And the final thanks here, of course, for taking your time here today to join us. I think there was concern about whether some of the material would be available. So I did mention earlier on, we will make a recording of this webinar available at a later date, and that will be posted on our YouTube channel. So thank you so much. Have a great afternoon, everyone.